Now I am going to dictate a legal passage at the rate of 120 words per minute based on latest Supreme Court judgment. Let's start. As is clear from section 3 within bracket 1, the further period of 12 months from 10/07/2023 was for those whose applications were validly filed and pending and where their applications have been submitted before the date of nomination. Subsection within bracket 1 within bracket B of section 3 of the Temporary Extension Act 2023 only revives the membership of those whose applications are pending by enacting a deeming provision, since they are now given a further period of 12 months from 10/07/2023 to furnish the validity certificate. Subsection within bracket 2 within bracket B clearly states that section 3 within bracket 1 was not to apply to members whose applications for validity certificate has been rejected by the scrutiny committee. Para. The contention of learned counsel for the appellant number 1 that there was no rejection and that it was only a filing or lodgement of the application and 0103/04/2021 by the scrutiny committee does not commit itself to us for acceptance. The rejection in section 3 within bracket 2 within bracket small b will also include those cases where application came to be rejected on account of defaults committed at the end of the applicants themselves. An application who has certain things under his control ought to have done everything that is under his control for the purpose of section 3 of the Temporary Extension Act 2023. This could also mean that section 3 within bracket 1 of the Temporary Extension Act 2023 would not apply, since there was no valid application filed before the nomination to the scrutiny committee and which was pending. That his application was not pending was also the undertaking of the appellant number 1, as explained here in above. Accepting the contention of the appellant number 1 would also amount to putting a premium on the concession given to a party who was taking the risk of contesting the election by not having a validity certificate on the date of the nomination. Stop. Para. For the above reasons, we hold that the appellant number 1 stood automatically disqualified as a member, since he failed to produce the validity certificate within 12 months from the date of his election. The protective umbrella of section 3 of the Temporary Extension Act 2023 will not be available to appellant number 1, since he is hit by section 3 within bracket 2 within bracket B for the reason that there was no valid application pending on the date of the commencement of the said act. Stop. Para. Additionally, the application was rejected under Rule 17. No doubt this cannot be a rejection which will result in the cancellation of his caste certificate. This is also reinforced by the fact that the District Caste Certificate Scrutiny Committee, by its letter dated 14/09/2023, stated that the appellant number 1's application dated 30/12/2020 was disposed for non-compliance and clarifies that his caste certificate dated 03/02/2013 is not invalidated. The appellant number 1 may take the benefit of the validity certificate issued to him on 12/07/2023 pursuant to his second application of 14/06/2023 for sustaining his caste certificate issued by the competent authority on 03/02/2013 for contesting in future elections and for claiming other concessions as may be available in law. Para. Appellant number 1 has ceased to be a member because of the automatic disqualification. In view of this, the proceedings of the Tehsil that dated 19/06/2023 rejecting the no confidence motion on the ground that the voting requirement of 3/4 of the members entitled to sit and vote was not fulfilled appeal cannot be sustained and is rightly been set aside by the High Court para. The net result is that the High Court was right in setting aside the rejection of the no confidence motion and in holding that the no confidence motion against the appellant number 2, Sarpanch, was duly carried. The High Court was also justified in directing that the appellant number 2 should stop exercising the powers as is Sarpanch and in further directing that the election for the post of village Sarpanch be notified afresh. The High Court was justified in quashing the declaration dated 1906-2023 declaring that the no confidence motion had failed para. We affirm the judgment and order of the High Court dated 20-09-2023 in writ petition number 7924 of 2023. In view of the above discussion, the appeal is dismissed. Interim orders will stand vacated. No order as to cost. Stop. Thank you.